Bhagat sir, I have joined. You can start.
हाँ हाँ
On your WhatsApp, right?
आता आता परत सांग.
हेलो सर. सर,
जी 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 भगत जी स्टार्ट करिए, मैं ज्वाइन हो
हाँ,
चुका
मैंने आपको प्रेजेंटर की लिस्ट भी भेजा है.
हूं। जी जी जी
यस यस सर, प्लीज. जगदीश सर आपको ये
हाँ
करेंगे
हाँ
सर,
हाँ
cooperate
सर
करेंगे.
सर सर आपको मैं को होस्ट करता हूँ, उसके बाद आप कंटिन्यू करिए.
यस भगत जी, वी हैव टू स्टार्ट.
हेलो. हेलो राफी सर. हेलो. 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 राफी सर.
Bhagat sir, you are there? हेलो खाना में सर बोले तो बोल खाना के बाद है वो मैंने कहा ऐसे हेलो नहीं सर के जाने के बाद बोला दोनों वाली का नहीं साले कौन हाँ क्या हम भी दिया हम भी नहीं
Hello. Am I audible? Is Rafe sir is there?
जी भगत जी आई एम देयर
Yes, Rafe sir ji. You can start. You can call the participant to present their papers.
ओके
So we can start on online session here of paper presentation, and parallelly we are conducting offline paper presentation at our industry at our seminar hall. So please continue.
यस यस भगत जी आई विल
Yes,
टेक
sir. Yes. I request participant to switch on their cameras.
नाउ आई वुड रिक्वेस्ट एकता सिंह रॉय मैम टू start his paper presentation. She is there? Sunita ma'am, Sunita Yadav ma'am is there? Okay. Now, Dr. Amina, you can start. Amina,
Ekta Singh Roy, I am just getting the name of him. Ekta Singh Roy is present, sir.
okay. अभी तो उन्होंने response नहीं है सर. हम Amina
Okay,
ma'am
okay.
start कर देते हैं. At least start
Whoever
तो.
want to
Sir, I
start.
am present, sir.
Okay,
Okay,
ma'am,
okay,
you can
sir.
start the presentation. You can share
Sir,
the
can you
screen.
kindly give me 5 minutes?
Okay, by that time, Amina ma'am, you can start if you are ready.
Yeah,
Amina,
yeah, sure,
if you are
sir.
ready. You can unmute Amina.
Yes, ma'am. Yes. A very good afternoon to everyone present over here. I'm Amina Khatun, Assistant Professor from Little Flower Degree College, Uppal, Hyderabad. I'm here to present my screen about the topic intellectual property rights. I'm just sending a request for sharing, sir. Kindly allow me to share. Sir, host has to allow me for sharing my screen.
Now I have given permission, ma'am. You can.
Okay, sir. 1 second. I'll just, yeah. Sir, is my screen visible to you?
Yes.
Yes, your screen is visible. Please start.
Okay. Okay, so I've introduced myself and I'm going to talk on the topic intellectual property rights in startups and entrepreneurship, organized by Yashwantrao Chavan College. And these are the contents which I'm going to discuss over here. And when we talk about intellectual property rights, we all know that it's something very important in present modern world, as we have grown technologically and we believe that we have to come up at the global standards. So intellectual property rights helps the startups in understanding and safeguarding their works related to either just trademarks, inventions, or any kind of artistic creations, so that that cannot be used unauthorizedly. Intellectual property rights definitely help in creating and safeguarding our creative things, including our innovations, either it is artistic work and any kind of literary work or anything which is done or created by us for the first time new. Then IPR is also crucial for startups so that they can protect their innovations from duplication or unauthorized use. So IPR is offering probably a competitive edge, and it also helps the investors to attract and give an assurance that whatever investment is being made by them in the organization or the business or the startup probably is safe, and whatever the work is being going to continue over there would be productive in nature. IPR, if we secure IPR, it provides the firms to capture a market with a proper advantage with their competitors, and it also helps them in growing potentially, putting up their efforts in a proper way. So IPR can be very strong selling point for the investors for demonstrating and putting up their offerings so that the investors get more attracted towards them because of the safety reasons. Licensing is another way of generating income, maybe through sales or through royalties. Now, when we talk about the categories of intellectual property rights, probably we can categorize them into 5 categories. First one are trademarks, copyrights, trade secrets, geographical indications, patents. These are probably 5 major categories on which I have worked upon. So the geographical indications, as we all know, it offers primary from the agricultural or any natural or manufactured product. It could be relating to any kind of artistic things also, which represents a particular area or a particular region, like which gives it significance. That's why we called it as the geographical boundaries which are bounded to it. Like Tirupati Laddu is very famous from Andhra Pradesh, and Banganapalli mangoes from Andhra Pradesh, Tulpanji rice from the West Bengal, etc. I have already mentioned on the pictures which have been taken over here. So Nagpur orange is another famous place. So this can come under geographical indications. When we talk about the trademarks can define about different size, shape, color, any kind of logo, or any kind of a particular thing which describes the product in a different and unique way, which if we preserve it with the help of trademarks, others cannot copy it or infringement can be saved. Then trade secrets are another very important very important components of IPR, whereby we can just safeguard our secret things. Like one of the examples I've shown over here is about the Coca-Cola. So another a few examples we can say that based on its taste, based on its certain kind of feature, which makes it unique from the others, so it can withstand in the market. And copyrights, we all know it safeguards our literary work, our artistic work, our paintings, photographs, music, choreography, or whatever the artistic work that can be saved if we go for the copyright. And patents are of different three categories probably over here. So design, utility, and plant patents can be taken care of. So when we talk about designs, it is about exterior look of a particular innovation or any kind of thing which has been developed or something innovated newly. On when we talk about utility patents, it's like protecting about the usage of particular systems or processes or any invention which have been made. I've given one sample patent form which can be issued from the side of the Government of India, which is the Payment Office Government of India, which then we can obtain this certificate after we go with the copyright patent. This is probably a sample of a patent. Now, when I talk about the significance of my study, it highlights probably about how intellectual property rights are being focusing on improvisation into startups and entrepreneurship. My study is all about thinking how we can connect IPR with entrepreneurship as well as development of startups into our economy. It also speaks about how competitiveness is important in today's modern world so that we can enhance our economy on a whole. The study also speaks about the difficulties or the challenges which are being faced up by the startups in securing and enforcing the intellectual property.
Madam, be
Like,
specific to your research methodology, to your findings, because
yes,
nearly 40 participants are there. It will be nearly
yes,
impossible to take the presentation.
yes, sir. Yes, I'll wind up quickly. So this is about the complexities, and benefits would be to the policymakers and researchers if they really focus upon how to literate about the intellectual assets for the business and growth. So objectives to comprehend how important intellectual property rights are to entrepreneurs and startups, to determine the various IPR components, their business related significance, and to understand IPR's application in startups. I've gone through various literary reviews, which speaks about how things have been really worked upon by the experts, and their reviews really matter a lot to bring some change. And when I talk about the methodologies, I've kept it very simple actually. So I've gone through the secondary data analysis, I've gone through case studies, I've gone through mixed methods, whereby I've taken the case studies relating to Flipkart, Biocon, Paytm, Tesla, etc. Now we all know that recently there is one issue going on between Tesla and TPI, which is having a conflict over the trademark infringement. So I have gone through those studies. Now, government has also taken up certain initiatives so that there can be an improvisation into the startups, as well as intellectual property rights schemes are being organized. So Maharashtra has organized intellectual property rights schemes, which is offering the financial assistance up to 2 lakhs and up to 10 lakhs, depending on domestic and international IPR. So there are so many other schemes which are also coming forward from the side of government. So when I go with the findings, IPR prevents from infringement. It also helps in having the legal ownership over the product or over whatever material is being innovated. Startups also motivate in helping unique developed products, and fear of imitation would be reduced. The risks are also there, but still we believe that we can overcome these risks. Coming to the conclusion part, so in the light of this, I can say that IPR plays a very important role in shaping our economy on and whole, because intellectual properties have been something which have been focused upon from the modern era, not from the previous times. So it definitely needs a lot of improvisation, and it definitely helps all of us to come forward by utilizing our technologies, our intellects, and putting up the things over here. So IPR has a lot of things to dealt with. The startups have to adopt IPR to full context, because without which it will be difficult for us to withstand at the market globally. Thank you one and all for giving me this opportunity. Thank you.
Thank you, ma'am. The next participant, Ekta ma'am. Amina, you can stop the
Yes,
screen sharing.
Yes, sir. I am just stopping it. 1 second.
Yes,
Yes,
sir, I'm here. Yeah. Sir, kindly allow me for the share.
1 second. I'm just putting this back.
Yes, Ekta ma'am, you can start now.
Sir, is it visible?
Yes, ma'am.
So my topic, so I'm Ekta Shingura, Assistant Professor of Pailan College of Management and Technology. So my topic is intellectual property and cryptography. Who owns the digital asset? Now, before going to that, first we have to know what is the IP, that is intellectual property, is the legal rights that is protecting the creative and innovative works. And what are the digital assets, that is the cryptocurrencies, smart contracts, NFTs, and blockchain-based digital contents. Now, the main question is who will truly own this decentralized landscape? Now, before going that, intellectual properties, there are types, that is the copyrights, trademarks, patents, and the trade secrets are there. That is, patents means that is new innovations in the blockchains and cryptography to protect that. Trademarks will protect the brand names, logos, and symbols in the blockchain project. Copyright, it's the original contents to protect the original contents. And trade secret means it is the algorithm process that is protecting. Now, cryptocurrencies and blockchain technologies, that is means the decentralized digital currencies based on a blockchain technologies. What are the key features? That is decentralization, transparency, immutabilities, anonymity, and traceabilities. Now, who owns the cryptocurrency? Mainly the users and the private keys who hold the private keys and will own the cryptocurrency. Exchanges means what are the, that is the ownership. Exchange is dependence on the platform policies, government regulations. No central ownerships are there, but there is a legal restrictions are being given. If it is lost or stolen cryptocurrency, it is a permanently, then it will be gone. Now, NFTs and intellectual properties. Now, NFTs means unique tokenized digital assets on the blockchain. So who will own this? It is the creators of the copywriters, smart contracts, or NFT buyers who owns the token, but may not own the, but they may not own the underlyings of intellectual property. And what are the challenges they face? That is the licensing ambiguities, copyrights, and legal enforcement. Now it is coming the smart contracts. It is smart contracts and IP ownership. Now, what
Madam,
is the
come
smart
to your
contract?
methodology and findings of your research paper.
Yes, yes, I am coming. So, just a little bit. That is the ownerships and actually that is the creating and by developing IP rights depends on the licensing and agreement, open resources, and property smart contract. Now, IP challenges, that is the lack of legal regulations are there, plagiarisms, copyright coins, enforcement issues, and interoperability risk. Now, how to protect the IP in cryptocurrency space? That is registered trademarks, use smart contract, monitor blockchains, and engage in open sources. Now, what are the case studies that is being in the real world? That is the Bitcoin and open sources IP. There is no single owners are there when the community driven developed. CryptoPunks, NFTs, owners conflict between creators and resellers. Ethereum smart contract, that is the open sources protocols and IP challenges. Ripples and SEC, that is the legal battles over crypto classifications. These are the future trends, that is the involving regulations, blockchains, metaverse, and virtual properties, and AI generated NFTs. And the conclusions are that ownership in cryptocurrencies is complex, defining by private keys, contracts, and legal framework. NFTs blurs the lines of IP, and smart contracts are transferring IP management, automatically rights and loyalties. Legal clarity is requiring staying informed and changing laws and compliance. Now, sir, my paper is now on. I am already on the process of finding, that is the who owns the digital assets. The research paper is going on, sir. It's on process. Hello.
No issue, no issue. The next participant. Who is next available?
Sir, shall I proceed, sir?
Yes, yes, Charlie.
Okay, good afternoon to everyone. My name is Sharleen Vinoda, Assistant Professor of Commerce Computer Applications, St. Joseph College, Trichy from Tamil Nadu. Today, I will be presenting my paper of titling on Intellectual Property Rights in Entrepreneurship, the Challenges and Implications. This research is basically critical role on IPR, helping the entrepreneurs to protect their innovation, gaining the competitive edge. The study highlights the challenges of entrepreneurs facing when they are trying to leverage the IPR and the implication of business growth and government policies. IPR is a legal protection grant individually for individuals or companies for their innovation or creation or brand. This includes of patents for intervention, trademark for brands, and copyright for creative works like literature, music, and softwares. IPR is essential to protect the intellectual asset for being copied or used without permission, providing with the competitive edges in the market. Many entrepreneurs are facing several changes. This includes a lack of misunderstanding of IPR system and complex regulations and the high cost associated with filing and maintaining these rights. Why the IPR is important? Importance of IPR in entrepreneurship. IPR plays a vital role in entrepreneurship by providing a competitive advantage. By securing patent, entrepreneurs can provide the novel inventions, again gaining the executive rights of profits from them. Trademark shows allows the entrepreneurs to protect the brand identity. Copyright protect the creative works like books, music, and software. IPR can be a tool of commercialization. Entrepreneurs can use the intellectual asset to license their invention and enter into the collaboration with other business by providing the additional source of revenue. The barriers to adapt IPR. Here, the first is cost barrier can be a major issue. Filing of patent, trademark, or copyrights involve substantial unfunded cost, which maybe startups or small business find difficult to afford. Second one is complexity of legal framework adds another layer of difficulty navigating through the various international laws, particularly in emerging of economics with inconsistency of IPR enforcement can be challenges. Lastly, the cultural factors also play a role. In some cultural innovation is viewed as a collective effort rather than the individual achievement, which can be leaded to the less emphasis securing a formal IPR protection. IPR and business growth. The business growth entrepreneurs who protect their innovation through IPR can be differentiated. For best example, Apple company has successfully used a patent to safeguard their groundbreaking technology and maintaining a competitive edge in their tech industry. IPR is also a tool of scalability. Once protected, intellectual assets can be licensed to other business are used to expand the international markets, generating more revenue and helping the entrepreneurs scale with their operations. Government role in IPR adaptations. Government can simplify the IPR registration process, offer the financial assistance for patent filing, and providing the educational program to raise awareness about the importance of IPR. For example, National IPR policy in India is innovative to promote the adaptation of IPR among the Indian business. But in Europe, the European Patent Office has been taken up the steps to simplify the patent application process and make it more accessible for entrepreneurs, particularly in SMEs, small and medium entrepreneurships. The review of literature, the existing review on the role of IPR in entrepreneurship. Various studies highlight the strategic importance of IPR, innovation, and securing market position. IPR can be help the entrepreneurs to secure the funding as investors to prefer the company to protect their intellectual assets. This research approach is used to qualitative based on the secondary data from case study, academic research, and government policies reports to analyze the role of IPR in entrepreneurship. The findings. IPR provides numerous benefits. Entrepreneurs still facing the significant challenge. This include lack of awareness about IPR, a complex system, and high cost of production. The study also shows the opportunity IPR provides entrepreneurs who manage to protect their innovation against the market difference, attract the investment, and securing partnership that business growths are crucially in overcoming these barriers. Effectively, policy can be simplified in IPR process, reduce the cost, and promote the awareness among the entrepreneurs. The implications and for entrepreneurs. The important implication for entrepreneurs: without IPR protection, entrepreneurial risk is losing their competitive advantage as a competitor in many of their product and services. Without adequate protection.
Okay, ma'am. Okay, just a few questions from my side.
Yes, sir.
Your topic is very nice, that entrepreneurship and IPR.
Yes, sir.
Ma'am, can you explain that how can a startup or an entrepreneur protect their intellectual property effectively?
Yes, sir. First, they want to make their product in a consistent way, and they want to make filing of their trademarks and patent for their innovation. Then no one can copy their work and they can do. So they want to go for patent or trademark or copyright for their creative works. Then it can be half and more than the sustain. It is help them to sustain in the business. Then they can go for the next stage, sir.
Okay. And you can, and how does the government support entrepreneurs in India for patent
Uh,
filing anything?
Yes, sir. Nowadays, everyone is having lack of financial supports. When if suppose we are going to patent one thing, it costs around 25,000 to 45,000. We are not affordable of the small scale business is not able to affordable of that much of money. So government give a subsidy like 20% or 30%. It will create some kind of interest and awareness to the people to get the patent and copyrights, sir.
Okay. Thank you, ma'am.
Thank you. Thank you.
Next participant. Instead of list, you see that whoever is ready can start his or her presentation.
सर मैं प्रेजेंट कर सकती हूँ क्या?
जी जैन मैम, बताइए आप बिल्कुल।
हाँ जी, डॉक्टर जयश्री जैन।
Just a minute. Sarlin, can you stop? Yes, thank you. Dr. Jayashree ma'am, you can start.
Good afternoon, everyone. I am Dr. Jayashree Jain, Associate Professor, Department of Commerce and Management, Mata Gujri Mahila Mahavidyalaya, Autonomous, Jabalpur, MP. हमारे इस कॉन्फ्रेंस का बौद्धिक संपदा अधिकार के अंतर्गत मैंने अपना टॉपिक जो रखा है वो डिजिटल मार्केटिंग के विशेष संदर्भ में है। जैसा कि हम सभी जानते हैं, कला, साहित्य एवं संस्कृति जीवन के तीन महत्वपूर्ण विधाएं हैं और इन तीनों का सीधा संबंध मनुष्य की बुद्धि और बौद्धिक क्षमता से है। और बौद्धिक संपदा अधिकार एक कानूनी अवधारणा है जो बौद्धिक संपदा उनकी बौद्धिक रचनात्मकता के स्वामियों तथा सृजनकर्ताओं को व्यक्तिगत एवं निजी अधिकार प्रदान करता है, ताकि कोई भी व्यक्ति किसी दूसरे व्यक्ति की कला, साहित्य, संस्कृति आदि से संबंधित कृतियों एवं रचनाओं की नकल ना करे। और बौद्धिक संपदा अधिकारों ने प्रौद्योगिकी, वैज्ञानिक प्रौद्योगिकी तथा मेडिकल आदि सभी क्षेत्रों में बहुत तेजी से विकास किया। वैश्विक आर्थिक वातावरण में यदि देखें तो तीव्र परिवर्तन जिस हिसाब से हुए, व्यावसायिक पैटर्न ने विकास को बहुत प्रभावित किया और बौद्धिक संपदा को संभावित विकास तथा मूल्यों के सृजन केंद्रीय कारक के रूप में पहचाना गया। बौद्धिक संपदा को डिजिटल मार्केटिंग के साथ हम यदि देखते हैं तो वर्तमान समय में इंटरनेट का समय, जिससे व्यवसायों के लिए कई प्रकार के अवसरों का द्वार खोल दिया। जब इंटरनेट नहीं था तो वो व्यवसाय भी बहुत सीमित क्षेत्र में होता था और हमारे ग्राहकों के पास सामान खरीदने की भी बहुत चॉइस नहीं थी। लेकिन जब से इलेक्ट्रॉनिक माध्यम से व्यापार जगत में प्रवेश हुआ, तब से सामान खरीदने और बेचने का चलन ही हमारा बदल गया। डिजिटल मार्केटिंग में इलेक्ट्रॉनिक डिवाइस का उपयोग एक आम बात हो गई, जिससे कई तरह के उपकरण जैसे खोज इंजन, सोशल मीडिया, ईमेल, वेबसाइट जैसे डिजिटल चैनलों का उपयोग व्यवसाय में हो रहा है। इस प्रकार हम देखें तो मार्केटिंग का कोई भी रूप जो ऑनलाइन मौजूद है उसे हम डिजिटल मार्केटिंग कह सकते हैं। आज बड़े दुकानदार से लेकर छोटे दुकानदार तक व्यवसाय में इसका उपयोग कर रहे हैं और सोशल मीडिया नेटवर्क और गूगल डिजिटल मार्केटिंग को बहुत बड़े उदाहरण है। बौद्धिक संपदा के अंतर्गत ये दो टूल्स इस तरीके से पूरे व्यापार जगत में काम कर रहे हैं। बौद्धिक संपदा अधिकार हमारी वैश्वीकृत दुनिया का एक पहलू है और इसका बड़ा हिस्सा डिजिटल चैनलों के माध्यम से। और डिजिटल मार्केटिंग एक ऐसा चैनल है जो आपके ब्रांड की प्रतिष्ठा और छवि की रक्षा करने और लगातार ग्राहक की वफादारी बनाए रखने के लिए कई अवसर हमें प्रदान करता है। और इसके अंतर्गत हम 4 पिलर देखते हैं जो कि हमारे और पार्टिसिपेंट्स ने बताया पेटेंट, कॉपीराइट, ट्रेडमार्क, ट्रेड सीक्रेट आदि। लेकिन आवश्यकता है कि इस बौद्धिक संपदा को इसके साथ जोड़कर हम कैसे लोगों के पास तक पहुंचाएं और एक अच्छी व्यावसायिक रणनीति बना सके, ताकि हम बौद्धिक संपदा के साथ में व्यवसाय जगत को बहुत आगे बढ़ा सके। विश्लेषण स्पष्ट करता है कि डिजिटल मार्केटिंग बहुत प्रभावी हो सकता है, वह शर्त है कि बौद्धिक संपदा से जोड़ा जाए। पेटेंट, ट्रेडमार्क और कॉपीराइट हमारे लिए अमूल्य हैं, पर उनका उचित उपयोग किया जाए। और बौद्धिक संपदा अधिकार ब्रांड की पहचान से लेकर रचनात्मक अभियानों तक मूल तत्वों की सुरक्षा में महत्वपूर्ण भूमिका निभाते हैं। ये अधिकार हमें सुनिश्चित करते हैं कि मूल सामग्री, आविष्कार और डिजाइन हमारे सुरक्षित है। डिजिटल मार्केटिंग में सबसे गंभीर खतरों में से एक यह है कि कितनी आसानी से छवियों, वीडियो, एल्गोरिथम और अन्य सामग्री को बिना किसी अनुमति के केवल कुछ क्लिकों के साथ लिया जा सकता है और इंटरनेट की पूरी दुनिया में प्रसारित किया जा सकता है। इस सबसे बचने के लिए बौद्धिक संपदा का पंजीकरण स्वामित्व के लिए आधार को मजबूत करता है और मुकदमों के दौरान एक वास्तविक पैर जमाने का काम करता है। डिजिटल युग में इंटरनेट और नई
मैडम
तकनीक
आपने पीपीटी नहीं बनाया?
सर पीपीटी तो था और नेट की प्रॉब्लम हो रही है तो वो शेयर नहीं हो रहा, पेपर सबमिट है सर।
ठीक 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 ठीक।
लास्ट
आप
मेरा
कंक्लूड कर
कंक्लूजन है
सकते हो
सर
मैम,
कि
आप कंक्लूड कर।
हाँ हाँ जी, बौद्धिक संपदा चुनौतियों का प्रभावी ढंग से समाधान करने के लिए कानूनी और तकनीकी विशेषज्ञों के बीच सहयोग महत्वपूर्ण है और एक साथ काम करके हम बौद्धिक संपदा अधिकार की रक्षा करने और डिजिटल युग में रचनात्मकता और नवाचार को बढ़ावा देने में मदद कर सकते हैं। इस प्रकार से ये कहा जाए तो डिजिटल युग में इंटरनेट और नई तकनीक के उदय ने बौद्धिक संपदा के निर्माण, वितरण और उपभोग के तरीकों में क्रांति ला दी है। थैंक यू सर।
ओके, थैंक यू मैम। नेक्स्ट पार्टिसिपेंट।
Good afternoon, sir. Hello. Hello.
यस मैम, गुड आफ्टरनून यादव।
Good afternoon, sir. I'm
Sir,
Sunita
can I
Yadav.
present
May I
myself Harshita Bhartiya?
मैडम सुनीता मैम को प्रेजेंट कर दीजिए, आप फिर करिए उसके बाद।
Okay, sir.
Yes, sir. Thank you so much. Thank you so much for giving me this chance. Good afternoon, everyone. My actually research paper is titled as AI generated work and copyright protection. And I created a PPT right now, because now I am not able to connect my laptop with the internet. So can I share my screen, sir?
यस मैम।
Give me 1 second. Just 1 second, sir.
Yes, ma'am. If internet problem is there, next participant can start because we are having nearly 34 participants.
Sir, can I start?
Yes, yes.
Okay, sir.
वालेकुम सलाम जी, बोलिए। जी जी जी, बोला था मैंने। क्या बोले? अच्छा।
A very good afternoon to
अच्छा।
all. Sir, am I
हेलो।
audible? Hello.
यस, यू आर ऑडिबल।
Okay. A very good afternoon to all. I, Dr. Kavleen Kaur Khanuja, from Mata Gujri Mahila Mahavidyalaya, Autonomous Jabalpur, would like to present my paper. The topic of my paper is IPR education and awareness among entrepreneurs, assessing knowledge and proposing educational frameworks. Sir, intellectual property rights play a crucial role in entrepreneurship, ensuring business sustainability and innovation protection. However, many entrepreneurs, particularly in SMEs and startups, lack adequate knowledge of IPR, leaving their business vulnerable. The complexity of IPR landscape influenced by technological advancements and globalization further increases the challenges of entrepreneurs that they face. So, sir, I could say that the IPR knowledge gap between the entrepreneurs and the policymakers is very much. In my study, I could see the business values up to 80% of the startup value may be uh, that they don't know the knowledge, and the deficiency is less than 30% of the entrepreneurs have clear understanding about how the how to protect their intellectual property right. If they have the knowledge also, they don't have the wisdom to protect it. This was the gap that I had studied. Now, the impact of knowledge gap. This knowledge gap impacted business sustainability, that they were facing risk to their business due to inadequate IPR protection. Innovation protection, the lack of IPR knowledge hindered innovation and growth in the global market. They didn't knew how to deal with the global marketers. And for the economic growth point of view, the knowledge gap impacts broader economic innovation and growth. For this study, my objectives my objectives of this study were to highlight the needs of structured IPR education for entrepreneurs, identify knowledge gaps and impact of IPR awareness on business success, proposes an educational framework tailored to entrepreneurs' practical needs. For that, I had made the null hypothesis that there is no significant relationship between entrepreneurs' IPR knowledge and their business success in digital economy. Alternative was that these levels significantly correlate with greater business success and digital economy. The sample size of my study was 200 entrepreneurs. The statistical analysis was Pearson's correlation of coefficient, that was 0.274. T statistics was 4.010 and p value was less than 0.001. The results were of my study, the results were that entrepreneurs with high IPR knowledge scored 17.4% higher in business success than those with low IPR knowledge. The T statistics exceeded the critical value, and the P value confirms this statistical significance. So, my null hypothesis was rejected, proving a positive relationship between the IPR knowledge and business successes. Interpretation was that in the correlation strength was moderate. The correlation strength was moderately positive correlation, that was my R was equals to 0.274 between IPR knowledge and business success. Whereas in group comparison, business success scores increases progressively with higher IPR knowledge levels. In business implications, entrepreneurs were higher IPR awareness, achieved better revenue, market share, and innovation performance. Improving IPR education can enhance sustainability, and competitiveness. The findings were that 65% of the entrepreneurs have limited understanding of IPR, 78% were unaware of international IPR protection, 82% struggle with choosing appropriate IPR protection strategies. Only 23% had formal IPR training. Now the knowledge gaps were the types of protection, international mechanism, cost-effective strategies, and digital rights management. Now I come to the last part, proposed educational framework, that it was proposed in three tiers. Okay. First was foundational level, basic IPR concepts, types, protection, and importance in business strategies should be told to them. And in second phase, it was practical implications, that industry specific strategies, cost effective protection methods, and IP portfolio management should be taught to them. And in the advanced implementation, international IPR protection, commercialization strategies, valuation methods, and strategy IP management should be taught. This study provided a structured approach to improve IPR education, equipping entrepreneurs with the necessary knowledge to protect and leverage their intellectual property for sustainable business success. Thank you so much, sir. Hello. Sir, I'm done with my presentation. Sir, am I audible?
So can I present?
Hello.
Good afternoon, sir. Can I present next, please?
Hello. Hello, sir.
May I present, sir?
So may I present?
Next participant.
Sir, can I go next, please?
Yes.
Okay. I'm just sharing my presentation. I hope my presentation is visible to everyone. Okay, good afternoon, everyone. I'm honored to present my research on algorithmic authorship in India, a doctrinal analysis of challenges in IPR in the age of generative AI. So I am Sonam Nagar, a research scholar from Dr. Babasaheb Ambedkar Marathwada University, Chhatrapati Sambhaji Nagar. This presentation is a part of National Seminar on Intellectual Property Rights 2025, hosted at Yashwantrao Chauhan College. Today, I will discuss how AI, that is artificial intelligence, transforming creative authorship, the legal challenge it presents, and the urgent need for policy reforms in India. Let's begin with the introduction. Now, imagine if an AI system is composing a poetry as profound as Mirza Ghalib. So who owns this creation? The developer, the user, or is it free for public use? Currently, Indian copyright law, that is Copyright Act 1957, mandates human authorship, meaning AI-generated work lack proper legal recognition. So now this presentation will explore the existing legal framework for AI-generated content, global precedents and case studies, challenges and risk of algorithmic authorship, the need for legal reforms to address any AI-generated intellectual property data. Let's first understand the objective of this research. This study aims to address the questions like, how does Indian copyright law treat AI-generated works? What global legal framework exists for AI authorship? What are the gaps or challenges in AI copyright law? And how can India reform its legal structure to accommodate AI-driven creativity? So by answering these, we can shape a balanced approach to AI and copyright protection. Now let us understand what is intellectual property rights. So before diving into AI authorship, let's quickly review what intellectual property rights is. So intellectual property rights include your copyrights that protects original artistic or literacy works, the patents that protects inventions, industrial innovations, the trademarks that protects brand identity, and trade secrets that protects your confidential business information. Now, what is the challenge? So AI-generated works do not fit neatly into these categories under current Indian law. Now, what is the global legal precedents? Let's understand that. So we have understood the Indian perspective. Now let's see the global legal precedents. So globally, different nations have taken varying approaches to AI-generated authorship. For example, United States, where Thaler versus Perlmutter, where AI cannot be an author, was declared. In United Kingdom, it states that copyright granted to humans arranging AI-generated content cannot be given. In European Union, human input is essential for copyright taken as a stance. And in China, more flexible approach is given where it allows partial copyright to AI-assisted work. India needs to examine these models to develop its own framework. I have taken few case studies to understand this more clearly. So some of the significant legal cases shaping AI copyright law include Zarya of the Dawn, which happened in 2022, where AI-generated comic denied copyright in the US. Then Thaler versus Commissioner of Patents, where AI-created inventions were rejected. And in 2023, where Getty Images versus Stability AI, where AI data set copyright infringement case was filed on AI data. Now let's talk about the methodology for the research I have taken into. To analyze this issue, I followed a doctrinal legal research approach where comparative legal study, wherein I examined laws in India, US, UK, EU, and China. And also I have taken a few case laws to review the AI-related court rulings, and study of such cases were done. Then policy review was done to understand and assess copyright regulations and ethical AI practices. This approach helped me identify the gaps in Indian copyright law. Now let's switch to the finding and discussion. The key findings of this study reveal major legal challenges. Like defining AI authorship. So AI lacks legal personhood because copyright is given to a human. So AI doesn't have such personhood. So making that legal personhood to AI will make ownership little clear. Till now, it is little unclear. The second finding is copyright ownership disputes. So should the rights belong to developer, user, or AI itself? This has to be given a proper light. Then third finding was liability issue. If AI produces infringing content, who is responsible? This has to be clearly given a statement into. Then the fourth one was creative economy. So will AI drive content replace human creativity, whether human creativity will be replaced or what? So these issues necessitate urgent legal intervention. The proposed legal reform that I would suggest based on my research, I propose the following legal reforms. First one is defining AI generated authorship. So introduce new legal provisions so that we can create AI created works will have a proper authorship in that. Second proposal that I would give is adopting a hybrid copyright model wherein assigning copyrights to human who direct AI generated content. The third proposal I would give is develop AI specific intellectual property right laws. So separate AI created work from traditional copyright work, right? So there should be a little different approach for giving a recognition to that. Then the fourth one is ethical and fair use. So there should be a platform or a space where human artist and the human creativity should be given a safeguard from AI exploitation. The fifth is international standardization. So we have to align, because this is a global village now, we have to align India's copyright laws with the global AI copyright regulations. So these steps can help India develop a balanced AI copyright policy. Now, what are the policy implications? So these legal reforms have significant implications for different stakeholders. For policymakers, legal updates are necessary to regulate AI authorship. For courts, judges must interpret copyright laws flexibly for AI-driven cases. For the creative industry, a revenue sharing model can protect human
Yes,
artists.
ma'am, you can conclude.
Yeah, sure. So if I want to conclude here, I would like to say that AI is revolutionizing creative authorship but lacks legal recognition. A hybrid authorship model can balance AI innovation and human rights, and India must modernize its copyright laws to accommodate AI-driven content, and global collaboration is needed to harmonize AI copyright laws. So by implementing these reforms, India can foster an innovative yet legally protected AI-driven future. Thank you so much for giving me this opportunity. I conclude. Thank you.
Good afternoon, sir. May I present?
Hello.
Sir, I'm audible?
Hello, sir.
Sir, may I present?
मैं प्रेजेंट सर मैडम आप प्रेजेंट करो अच्छा आई एम ऑडिबल मैं ऑडिबल मैम Ma'am, I have not prepared my PPT. Only in few words I am going to conclude. Am I audible, ma'am?
Sir, ma'am, I am audible?
Yeah.
My screen is visible? Good afternoon to all. I, Simarpreet Kaur, Assistant Professor, Department of Commerce and Management.
ये चालू कर।
मैडम सिमरप्रीत मैडम आप प्रेजेंट करिए आपका स्क्रीन दिख रहा है
Yes, ma'am. Very good afternoon to all. My topic is IPR for entrepreneurs in emerging markets, barriers and challenges for developing economics and Indian perspective. Intellectual property right play a critical role in fostering innovation and economic growth, especially in emerging markets like India. For entrepreneurs, securing IPR can enhance business competitiveness, attract investment, and facilitate global expansion. IPR have emerged as a fundamental pillar of modern economies, serving a crucial mechanism for protecting and
Yes,
incentivizing.
Kaur ma'am, you can end the next participant.
Objectives of my research is to examine the relationship between IPR and entrepreneurial innovation, to investigate the procedural inefficiencies in India's IPR system, and also the impact on entrepreneurial growth. Next is to evaluate the effectiveness of existing IPR enforcement mechanism and to assess the awareness and understanding of IPR among Indian entrepreneurs. The importance of IPR is innovation catalyst. For entrepreneurs, securing IPR can enhance business competitiveness, attract and facilitate global expansion. IPR actually protects and incentivizes innovation, driving economic growth. And strong IPR also attract foreign investment and facilitates technology transfer. There are many challenges for Indian entrepreneurs like high registration cost, lengthy procedures, and enforcement. Actually, weak enforcement mechanism lead to high rates of infringement of IP, and patent filing fees can strain limited startup budgets. I have chosen some case studies like turmeric and neem plant controversies in 1990s. A US company obtained patents for turmeric and medicinal uses of neem. And India faces a challenges, argues these were not novel inventions, but a part of traditional involvement, traditional knowledge. And their outcome is India has successfully revoked the patents, highlight the need for stronger traditional knowledge and protection. Next case studies that I have taken is Basmati rice geographical dispute. In early 2000s, Rice Tech US company applies for a patent on a rice and marked as Basmati. And India opposes for these, and India argues Basmati is a geographically linked product that is only grown in India and Pakistan. And its outcome is India successfully revoked Rice Tech patent and need for proactive GI registration. My next case study is copycat designs in the fashion of Sabyasachi. The challenge they face is fast fashion brands and small manufacturers replicate Sabyasachi's designs without authorization. And stronger copyright laws and better enforcement mechanism are needed to India's fashion industry. The recommendations for a stronger IPR ecosystem is fast track patent, financial incentives, and IPR awareness campaigns. It is necessary to conduct training programs to aware about the IPR in regional languages and reduce patent approval time through digital automation. Recommendations also specific dedicated IPR code should be there, which provides specialized expertise, and PPP, that is public private, collaborate with industry bodies to provide legal assistance to startups. And I conclude that a well structured IPR framework will enable Indian entrepreneurs to compete in the global market, drive innovation, and enhance economic growth. Thank you. Thank you, sir.
Yes, thank you, ma'am. Next participant.
Good afternoon, sir.
Yes, good afternoon, Meghna ma'am.
Sir, I'm audible, right?
Giri ma'am.
Yes, sir. Yes, sir. Sir, actually, I'm connected with two devices. I'll just disconnect one device. My camera will not be visible for you people, only audible. So please bear me. I hope I'm audible, sir.
Yes, ma'am. Yes.
Yes. The PPT is visible, sir? Hello?
Yes, madam, you can speed up the screen sharing. Many
Yeah.
participants are still remaining.
Sir, can you see my screen, sir? Is it
Yes, it is. Your screen is
visible?
visible. Yes, yes.
Yeah, okay. Good afternoon, everyone. And
You share your PPT, but only your screen is visible. Just
Acha,
don't
you're not
share.
able to see my PPT?
Just stop the sharing and share it again.
Okay.
By the time you can start.
Is it visible now, sir?
No. You stop the screen sharing, ma'am.
You want me to stop the screen sharing?
Again, start then.
Okay, now I'll just try once. Is it visible now, sir?
Just a minute. Now it is visible.
Okay. Good afternoon, everybody. And thank you so much for giving me this opportunity to present my paper today. My study is the impact of intellectual property rights on consumers in traditional markets and e-commerce. Now, people might be wondering, when we talk about intellectual property rights, where do this consumer come in, right? So basically, when I received this paper presentation topic, one incident struck my mind. I would like to share that incident. Once I was in a very small village in Maharashtra. One lady came to the shop and she asked the shopkeeper that, can you give me washing powder? The shopkeeper asked her, which washing powder? त्याचा नाव असेल ना, उसका कुछ नाम होगा. Then she said, मुझे नाम नहीं पता है. I don't know the name of the washing powder. Then he asked, can you just tell, like, do you have any picture, any symbol on it? Then she said, yes, one girl will be dancing on it. Then he said, Nirma? Yes, she said Nirma. So this is what a symbol image, that is nothing but an intellectual property right, what a producer has. So the same has an impact on the consumers when they try to buy the products in the market. So this, with the same incident, I took this study and I'm gonna explain what my study is focusing on. So basically, my objectives of the study are to examine the role of IPR in traditional commerce, to explore how IPR operates within e-commerce, to compare consumer experience in traditional versus e-commerce, and to analyze how IPR ensures product quality and authenticity in both physical and online markets. So my research methodology, I've just used both the primary data and the secondary data for my study. While doing my primary collection of my primary data, I've used a questionnaire and I've done a small survey in the rural and urban areas of Hyderabad. So I have taken a sample of 200 consumers, wherein urban, rural, people have been taken into consideration with the age group of 18 to 60. So both male and female. So you can see the graph pie chart here. So I'm not going to explain this directly. I'll go to the point. Now, IPR awareness and engagement, which is very important. When I'm studying, I just wanted to know how many consumers are aware of the intellectual property rights. And based on that, when they are doing the shopping, will it really have an impact? So if you see in this, there are many of the people who 72% of the people are aware of IPR and 28% of the people are not aware of the intellectual property rights. That means the images, symbols, the brand, what the products have on their brands or the products. So the importance or the role of intellectual property right in traditional commerce, when asked like how important it is when you're doing your shopping in a physical store or the traditional market, you can see that 72% believe it's very important to know the authenticity and the quality of a product. As a consumer, we all know whenever we want to buy a product, we would like to know whether it is authentically a right product or not, so that we get the best quality. I'll give you a simple example what I came across. A few years ago, we bought one Parle biscuit, Parle G. We all know the Parle G has a small girl picture. The same was there on that also, but instead of Parle G, there was something else, Parle J. So we understood that it is not an authenticated product and we just returned the product. So here we can understand that intellectual property rights play a very vital role when you do the traditional marketing. And when we talk about the e-commerce, most of the people believe, yes, it is important, but when I did the survey, most of them don't bother about this authenticity or the IPR in online purchase, because they are all aware that the products can be returned if it is not an authenticated product or if there is any quality defect. So when doing online shopping, most of them believe कि ठीक है, अगर है quality, authenticity है या नहीं है, it doesn't make a difference, as we have an option of returning the products. Now, counterfeit products, that means imitation, has become more and more popular in the online business. For every product, you will get an imitated product. If you take mostly in the garments field, there are so many imitation variety that if one dress you can purchase for 1,000 rupees, the same dress will be available for 100 rupees also. This is nothing but a counterfeit product. So when asked the customers, do you find these kind of counterfeit products or imitative products in the physical or traditional stores? Most of them said no. When we asked the same question for the e-commerce, most of them said, yes, we do have many counterfeit products, but we are not worried because we can return the product. So when I compared the traditional commerce and the e-commerce, I found that most of the consumers who are like, age between 18 to 40 prefer the e-commerce rather than traditional commerce. And 50, 60, these age people still believe in purchasing the goods from a traditional market or a physical stores because they want the authenticity and the quality of product to be the same. So when asked, they said, yes, the IPR plays a very vital role in purchasing goods in a physical stores rather than in a e-commerce stores. So I have done a chi-square test which was conducted and which shows a significance difference in the e-commerce and physical stores. Most of the respondents said that yes, physical stores have more authenticity and e-commerce stores do not have much of the authenticity. So it's better going for e-commerce, says the teenagers and the middle ages, and old ages accept that still physical and traditional stores are the better ones. So my findings and conclusions are that the study highlights that IPR plays a significant role in protecting the product authenticity and ensuring consumer trust in both traditional and e-markets, but still there are a lot of loopholes in the online market or online e-commerce marketing. So I suggest and recommend that the government and companies should promote consumer awareness.
Yes, thank you, ma'am. Thank you. Next participant.
Yes.
Sir, am I audible, sir?
Yes, you're audible.
Myself, Gautam Kanani.
Yes, Giri, ma'am, you can stop the screen sharing.
Sure, sir, sure.
Could you please?
Yes, Patel, sir, you can start the sharing.
Okay, sir. Sir, my screen is visible or not? Good afternoon, everybody. Is my voice audible, sir? Hello?
Yes, ma'am. Yes, sir.
Okay. Myself, Dr. Gautam Kanani, and my colleague is Dr. Harish Patel. We have made a research on stock market analysis for the study of BSE, Sensex, and NSE Nifty volatility with regards to intellectual property rights. We have divided our research paper in 8 parts, that is started from abstract to references. In abstract, there is a elections significantly impact a nation's economy and financial landscape. Means here we have selected 3 companies, pharma, techno, and media industries. In pharma, we have selected a Cipla, Bajaj Health. In techno, there is a TCS, Infosys. In media, Sun TV, TV18, etc. Means those companies are which are registered on BSE and NSE Sensex. Here I want to say that the strong IPR protection helps the companies secure exclusive rights over their innovations, boosting their revenue and investors' confidence, which positive impact on stock prices. Also, the strong IPR of the companies here in BSE and NSE data, that is, if there is a framework, it helps to the foreign investors and also make the stability on investment purposes. The research focuses only on election results on BSE Sensex and NSE Nifties, the companies who are adopting their IPR strategies in their businesses. Here the introduction, in introduction, there is a significance of general election. Means here we have conducted every 5 years, we know that every 5 years there is an election and shaping economic and financial sectors. Political parties with diverse ideologies impact investor sentiments differently. And also the political risks affect to the market participants, analysts, and policy makers. That's why it was very important to know the result of the before election and after election of the companies. Market sensitivity is there, and IPR sensitive industries that we have considered, that is pharma, tech, and media industries that highly impacted on by policy changes. The main reason why this study matters: identifies market anomalies. Anomalies means the parameters which identify us the market volatility linked to the election results. And also it offers the valuable insights for the investor, because it is nowadays, that is the, what we say, emerging dream of the investors. And the conclusion is that political outcomes temporarily influence the stock market, but don't dictate long-term trends. Understanding these trends can help investors and policymakers make informed decisions. The review of literature. The Sajli Abedin in 2010 has made a research on political cycle effect on stock return in New Zealand, and Khalid in 2010. His study found that both positive and negative political shocks significantly affect the market stability. And also the Kabiru, he has made research in 2015, impact on general election on stock returns at the Nairobi Securities Exchange. And also Balaji, 2018, we have taken base of the for reviews. Now I hand over my research to my colleagues from the research methodology section. Dr. Harish Patel, could you please continue with this?
Very good afternoon, sir. So I will continue with the research methodology section. The primary objective of the research is the stock market reaction to the election results, that is study of BSE and NSE Nifty volatility with regards to IPR. Now here in this study, exploratory research design is used, and data collection, that is time period for this particular study, is 1999 to 2024. Now to measure the market volatility, we have taken 3 key periods before and after the election result announcement, that is before 30 days, after 30 days, before 15 days, and after 15 days, and 1 week, that is 7 days. So basically this time frame enables a comparative analysis of the short-term and medium-term market movements. These are the basically statistical techniques that we have used in our study, that is daily average return calculation, variance and volatility analysis, and event study methodology. So the limitation of the study is only focused on Sensex and Nifty indices, and study does not account for the other important macroeconomic factors which are also very crucial, that is interest rate, inflation, and global market influences. These are the time period that we have taken into this study, 1999 to 2024. On 2024, that is current period, on 4 June 2024, result was declared. So we have taken 3 time period: before 7 days, before 15 days, and before 30 days. Same way, after 7 days, after 15 days, and after 30 days. These are the main parameters that we have found out: pre-election market behavior, immediate post-election reaction, long-term impact, sectoral impact, and IPR-driven industry reaction. So basically in IPR industry reaction, evaluating how changes in the patent laws, copyright enforcement, and trademark policies post-election influence stock market performance. This is the average return of the Sensex, that is BSE and NSE. We can able to see from 1999 to 2024. Before 30 days, average return was 0.005. Before 15 days, it was 0.007. And before 7 days, the average return of the BSE was 0.006. And same we can able to say before 30 days, the average return was 0.0005. And after 30 days, average return was minus 0.0012, if talking about the BSE. And same way we can able to see the data of NSE. These are the data of average return of the variances, that is BSE and NSE. We can able to see before 30 days, it was in 2024, it was 0.02. And after the same variances, that is 0.03. And same way NSE data is given. This is how we have find out the before election mean return and after election mean returns. before 30 days, before 15 days, and before 7 days. This is what the variance is. That is why how we have found out variances before 30 days and variances after 30 days. We can able to see average daily variance. So here average daily variance of the BSE before and after election is approximately 0.00002018. That is 0.002%, indicating moderate volatility in the stock movement around elections. These are our finding. We can able to see before 7 days, that is May 28 to June 3, 2024, trend was moderate decline in both NSE and Nifty. Reason was investor caution due to uncertainty in election outcomes. Daily average return slightly negative. That is, we can able to see that is a NSE and BSE slightly negative. That is 0.3%. And BSE daily average return was 0.31%. Same way 15 days return. We can able to see trend, reason, and daily average return, and same way 30 days trend, reason, and daily average return. Same way, this is the result of, this is particularly in the year of 2024, if you're talking about, this is the 7 day after, we can able to see trend, reason, and daily. Before 7 days, if you're talking about, the trend is sharp fall on the election result. Reason is ruling party secured fewer seats than expected, leading to initial panic, later stability. And daily average return for 7 days, that is positive for NSE, that is 0.41%, and BSE's return is also positive, that is 0.38%. Same way, if you're talking about the 30 days, that is after election result declared, trend is market surge and hitting new highs in 2024, that is June 4 to July 4, 2024. Reason is institutional buying improved confidence in economic policy. Daily average return is positive for the NSE, and same way BSE return is also positive, that is 0.52%. So the finding revealed that stock market experienced significant fluctuations in response to election outcomes. Positive election result led to bullish market trends, whereas uncertain or unfavorable result caused market downturn. Additionally, policy continuity and economic agenda play a crucial role in stabilizing investor confidence post-election. Furthermore, most important, IPR sensitive industries exhibit heightened sensitivity to policy changes, with investor sentiment fluctuating based on expectation of regulatory support and restrictions in innovation protection. This is our conclusion. So election significantly impacts stock market volatility, particularly industries sensitive to IPR. Understanding this dynamic helps investors and policymakers anticipate risks, adopt strategies. So policy shift influence market stability and sectoral performance, making proactive planning essential. So basically, this insight contribute to financial literature, aiding in informed decision making for economic growth and investment strategies. So key takeaway: strategic awareness of election-driven market fluctuation enhance financial resilience and economic planning. These are our references. The 10 research paper that we have found out and we have taken base, and by finding our research gap, we have basically select this particular topic. So once again, thank you so much and giving us opportunity to present this paper. Thank you, sir. Now it's up to you. Thank you, sir.
Yes, next participant. Even if I am somewhere, no, you can start the presentation. Next participant. Hina ma'am, you are presenting. You are not audible. Hina ma'am, you are not audible. Harish Patel, you can stop the screen sharing if you have
Yes.
concluded.
Just wait.
हा मॅडम, झालं का सर? इथेच बसलेले आहे सर, विचारत होते. हा हा, बाहेर पाठवावं लागेल रे, एक अर्धा तास लागेल मॅडम त्याला. हा हा, येस, हा हा, येस, नाही नाही, काही प्रॉब्लेम, काही प्रॉब्लेम. येस. Hina ma'am, you are not audible. Next participant, any participant is available? Next participant, any participant?
Yes, sir. Yes, sir.
Yes, you
I'm
can
Jayant.
start my presentation in
Yes, sir.
screen share.
Yes, sir.
Hello.
Hello. Ma'am, just is my PPT is visible, ma'am? Yes, my PPT is visible, ma'am. Hello.
Okay.
Yeah. Good evening, madam. I'm Jayamati from Shankara College of Science and Commerce, Department of Commerce. Yes. Today, I talk about my topic is study on intellectual property rights and its significance of e-commerce. Once again. Yeah. Today, I talk about my topic is a study on intellectual property rights and its significance of e-commerce. This mostly is focused on the significance and rights of an IB is regarding for the e-commerce only. It's my abstract is and the concept based reference I have taken to the intellectual property was developed in 18th century with the first the federal stage of patents being passed in 1790 only. I focused for the scope of intellectual property rights varies from country to country, but generally anyone experience that falls within that durations for the copy of rights and law patents is protected for the intellectual properties. And my introduction is the IBIS, the term is used to describe the exclusive of rights that pertaining to the creativity of works that the including of the IBS, the innovation is based for that the literacy, artists, works, designs, symbols, and the images can be protected under IB, follow the law of rules and ethics. And my significance of the study based, once again, yes, of course, I have taken the majority of the business, the worldwide of the intellectual property to be much the variable assets than the physical property they may hold. And there are two way of significance I have taken in that study. Yes, one is focused for that worldwide e-commerce considers for the intellectual property base, and another one is the modern digital economy makes that importance of IBS e-commerce the practically for various usage. In addition, the creations of labors, experience, regulations, and procedures for the recording for the that's significance of the law. And my research objectives is based for the 4 types only. First one is the comprehensive history of overview of intellectual property rights, and to now the role of intellectual property rights in e-commerce. And then third one is to identify the e-commerce components covered by that IBR. And fourth one is to study the various types of intellectual property rights. This based for the, my research objectives. And my research methodologies I have taken collected for the only secondary sources for the related. As usual for the that various reports, research papers, and intellectual property rights were referred to a proper part of from various journals and articles regarding. And I have discussed for the once again. Good evening, ma'am. And I have discussed for the my history of intellectual property rights is 3 based for that. Yes, one is origin of history of patents and history of copyrights. Another one is trademark relevant. And team-wise, I have separated for the types of IPRs, patents, copyrights, trademarks relevant. And my intellectual property rights, its important role in e-commerce based for the protection of companies' business interest, and then protecting that's vital of components, and that's very important of the safeguarding goods and obtaining a pattern of permits. And another, the last one is the preserving patent trademark holders relevant. And finally, my conclusion is based for that. So only regarding once again. My important conclusions is based for that is only regarding the legal of protection intellectual rights, the promotes of surgeons in the developing a new concepts based for that new concepts and forming of strategic technologies based. This based is improve that sales of e-commerce operation is a growth of income and generating of the income, and rightful of intellectual property owners is only for it's useful for that. Because of the intellectual property protects this e-commerce and promotes e-commerce justice, while that appropriate of the safeguards for protecting and the intellectual property rights is taken only for that. My conclusion is it's enough. Thank you, sir.
Yes, next participant.
Yes, sir.
Sir, shall
Yes,
I read?
Phule ma'am.
हाँ,
करा start करा काही को.
okay. Thank you very much for giving me opportunity, sir. I'm Assistant Professor Dr. Jayashree Nagarakulle from ASC Arts Science College, Arts Science and Commerce College, Badnapur, District Jalna. My topic is intellectual. Am I audible, sir?
Yes, ma'am.
Yes, yes.
I have not prepared PPT, sir. Still, I'm not taking much more time. Intellectual property right in Indian entrepreneurial perspective. First of all, I want to make few. I want to discuss about what is intellectual property, and then copyright violation and startups. So, what is intellectual property? It is the rights. Intellectual property rights are the rights given to person for her or his creation of mind. It is the right of creator, innovator who creates or innovates something unique or new in any field area, where it may be literature, computer programming, sculpture. This right is given for certain period. After the completion of this period, it will become general. There are two categories of intellectual properties. Intellectual property right are divided into two categories: copyrights, rights related to copyrights, and industrial property. So what is the objective of copyright? The object of copyright is to promote progress, along with to encourage authors, composers, and artists to create original works. Initially, copyright law applied to only to copying of books. Over the time, other uses solutions as translations and derivative work, including maps, music, dramatic works, paintings, motion pictures, architectural drawings, sound recordings, and photographs. So copyright, what is copyright violation? Hacking, virus attack, cutting off communication, cracking, violation of privacy, data feedings, spreading misinformation, alteration of information, email security disruption. Second type of IP right is industrial property. Industrial property can usually be divided into two main areas. Trademark, if any company firm has its own logo or any trademark or icon which identify its ideas, from where it originates, from where this is for to ensure and stimulate for competition and to protect customers. Second is industrial designs. This property has been protected primarily to stimulate new innovations and the creations of industrial designs and trade secrets. This protection is given for a particular period, typically for 20 years in case of patents. Startups, how IPR ads in startups. Under the Startup India initiative, eligible companies can get recognized as startups by the Department of Promotion of Industry and Internal Trade, that is called DPIIT, through the Startup India. Initiative has executed various projects and undertaken recurring models to propel Indian startup ecosystem. For example, Bhaskar. What is Bhaskar? Bharat Startup Knowledge Access Registry. Bhaskar is envisioned as one top digital platform where diverse startup ecosystem stakeholders can seamlessly connect and collaborate, catalyzing the growth and success of the startup ecosystem across India. By providing a comprehensive platform for knowledge sharing, and search ability, ever increasing amounts of well stored in intellectual property flaring up. Intangible intellectual property assets have skyrocketed in total company valuation. Patents provide several advantages for our analysis. What are the advantages? It is in the interest of innovating firms and actors to get adequate protection for their IP. We can assume that they apply for the kind of protection corresponding to the nature of innovation, because we have no reason to think industrial innovation would be registered as a copyright. Data about applications would be true to the kind of innovation as in one particular country. Second is the World Intellectual Property Organization, that is WIPO, based in Switzerland, is in charge of receiving filings, administering the 26 international IP treaties, and resolving IP disputes among its 193 member countries. The rights granted by patent abstentions, whatever the kind of patent and whatever the country of origin, also refer to in IP rights as the filing office protect for a duration of 2E National Policy of IPR 2016. In May 2016, the National Intellectual Property Rights Policy 2016 was approved as a vision statement to direct the country's future IPR growth. Creative India, Innovative India is the motto of IPR Policy 2016. The Government of India has designated the Department of Industrial Policy 7 Promotion, that is DIPP, Ministry of Commerce, as the nodal department to coordinate, direct, and monitor the implementation and future development of IPRs in India. There are certain issues related to IPR in India. Issue of implementation. A significant hurdle is getting the judiciary and enforcement officials to address concerns with intellectual property rights, conflicts with overlapping provisions, or protection of intellectual property occurs when different bodies of intellectual property law simultaneously protect the same topic. It is challenging to balance private property rights in India. Issue related to plagiarism. Plagiarism is another serious problem. It is the act of taking another person's intellectual property, which includes words, slogans, designs, confidential information, and creative works of authorship, and utilizing them as one's own without acknowledging the original author or inventor. Improper enforcement of intellectual property laws in cyberspace. On the internet, intellectual property rights are applicable, but their enforcement is the key concern. Publishers contend that the internet undermines their rights to intellectual property since it fundamentally alters the nature and methods of publishing, leaving their products every susceptible to online piracy. Third, decentralized internet management. Due to internet's management being decentralized, anyone can misuse extensively disseminate work on the electronic network known as cyberspace through a variety of means. An individual can simply share a piece of art with news groups via email or on a personal website. The law governing intellectual property rights has caused issues for those working with advanced technology, such as computer programmers. The law stipulates that something must either be in writing to be protected by copyright or a machine to be protected by a patent. Fourth is no equivalent legislation to the Western copyright laws. Although the Indian Copyright Act followed international norms, Indian Copyright Act has a significant shortcomings when compared to Western copyright laws because India does not join the WIPO Internet Treaties. There is no equivalent legislation to the USDMCA in India. Protective measures for electronic data. The current Indian Copyright Act makes no mention of technological protective measures or the need to preserve electronic rights management data. The Indian Penal Code 1860 IPC contains several sections that could provide legal protection for technological measures. The IPC section 23 refers to wrongful gain or wrongful loss. Protecting traditional knowledge. Traditional knowledge is like a rich mine, especially in the medical area. Government of India is required to safeguard the traditional knowledge by prohibiting MNCs from obtaining patents on traditional culture. So I am coming to the solutions. For addressing IPR related disputes, a suitable resolution process is required. Second, India must fix any gaps in its IP laws and regulations if it is to fully benefit from the transformative advantages of a strong IP system. Third is the expansion of the innovation ecosystem with improved IPR safeguards is necessary for the success of India's flagship programs, Make in India and Startup India. To encourage the Indian industry to innovate as well as to protect and enforce their ideas, there has to be greater knowledge about the development, protection, and enforcement of IPR. Lastly, I conclude addressing the issues related to intellectual property rights requires a multi-pronged approach, including legal reforms, strengthening enforcement mechanisms, enhancing judicial capacities, and fostering culture of innovation and respect IPR. Second is, moreover, policies need to be inclusive, considering India's development needs, public health concerns, and the imperative to foster innovation and creativity. To improve efficiency and reduce the time needed to issue patents, India has implemented several improvements to its IPR framework. In the nation, innovation culture is becoming more predominant. India is in a good position to prioritize R&D. This has resulted in an increased rating in the Global Innovation Index over explaining factors and implications for the Indo-Pacific region. References I have used here: Intelligence Property Right Issues and Challenges in Digital Environment by Kaushal Chauhan. Secondly, all the websites and some of the articles. Thank you very much, sir.
Hello,
Hello.
is it audible now? Am I audible? Hello,
Yes, yes.
am I audible?
Yes, ma'am.
Yeah.
Thank you, sir.
Okay.
Good afternoon, all. I am Hina Gajera, Assistant Professor of J.D. Gabani Commerce College and Sri Swami Atmanand Saraswati College of Management. I am going to present a paper that is titled as Decentralized Intellectual Property Right, a New Era of Digital Rights Management.
Here is.
As we all know that intellectual property is crucial for the innovation and protecting creators' rights. Traditional intellectual property right management faces inefficiency, like high cost, slow processes, and vulnerability to infringement. There is a high processing cost, process is very slow, and there is a possibility of copy, and anything is possible. And infringement of the right is there. Then decentralized intellectual property right uses blockchain technology, smart contracts, and decentralized autonomous organization to revolutionize the intellectual property management. Here, in decentralized intellectual property, blockchain technology is used. Blockchain technology has the capacity to store the data which is immutable, that no one can copy the data. There is a one specific hash number which is given, and the property, whatever the author has created their art, music, anything can be stored on the blockchain technology. The smart contract has the capacity to take the royalties, whoever use the content. The decentralized autonomous organization is an autonomous organization. There is no any intermediaries. Without any intermediaries, this organization can manage all things. Here I'm trying to explore the potential applications, benefits, and challenges of decentralized intellectual property rights. What is DIP? That is decentralized intellectual property right. It's a blockchain-based system for managing intellectual property rights. In that, the technology used is blockchain, that is immutable records. The blockchain has capacity to record the data, which is immutable. Smart contract has the capacity to systemize the automated payments, and decentralized autonomous organization has capacity to govern all the things without any intermediaries. This decentralized intellectual property right eliminates intermediaries, ensuring the transparency and fair compensation. Literature review includes Bennett, who has invented a system that is IPFS, that interpollinatory file system, which enhances the digital asset security through decentralized storage. Butrin has innovated smart contracts, automated intellectual property transactions, which reduces the intermediaries. Smart contract, which is based on the cryptocurrency. Davidson, who has researched a paper in which he has write that decentralized intellectual property right reduces the transaction cost, democratize the IP protection. Murray and Davidson, who has identified the legal challenges required to adapting the laws for blockchain-based DRP. These are the literature review I have identified. Research methodology include objectives of this paper is study 6 to examine the fundamental concepts, uses, advantages, and obstacles of DIP. Approaches I have used here is the qualitative research, descriptive research. Data collection method is literature review. That is, we have used academic articles, white papers of cryptocurrencies, legal documents. Use cases where these intellectual property are already used are the art, music, publishing, and scientific research. Analysis is evaluating practical implementation, identifying challenges. I have identified many cryptocurrencies website and non-fungible tokens website over there. These particular tokens are used for the authenticity and transparency to protect the rights of the creator. Now the application of DIP is it can be applied in the art and digital content, that is in the form of non-fungible token, which is popularly known as NFT, provides proof of authenticity and resale royalties. That is, a person who has created a particular art can create a particular NFT. It's a particular digital, it can be a particular digital art, or it can be our research paper also. We can create an NFT and we can register in a different website. It can be OpenSea, Rarible. There are a number of open NFT markets are available over there. We can register and we can get the authenticity of that particular art. And when we resell the same, anyone is purchasing the same, then we can get the royalty if we are the creator. Decentralized storage system, which reduces the censorship risk, is there in the art and digital content. if we talk about the musical industry, then in musical industry, we can tokenize the music. If we are the singer, if we are the tune maker, we can tokenize that particular art on the non-fungible token, and we can store the same into blockchain technology, and we can get the royalties. Then scientific research and patents can also be secure. We can also register them. We can also identify the peer reviewed on the blockchain technology. Blockchain technology ensures transparency and prevents data manipulation. Even the software developer can also use the blockchain-based open source licensing with automated micropayment system. Publishing and journalism can also done on the blockchain technology, and we can automate the royalties payment. Or we can get the proof of the authorship and fair revenue distribution. If we talk about the benefits of decentralized intellectual property right, then there are a number of benefits over there. The first is the transparency and security. Because of the immutable records capacity of the blockchain technology, it reduces the broad fraud and unauthorized use. Fair compensation is possible because of the smart contract is there. Elimination of intermediaries there, because there is no need to have any intermediaries who can manage all things. There is one thing, that is the decentralized autonomous organization, which is fully decentralized. There is no human interferences there. It is working it is totally based on the algorithm. Fourth benefit is global accessibility. Obviously, we all know that blockchain technology based or everything is globally accessible. Then prevention of crypto right infringement. As we all know that there is a copyright infringement is there. Anyone can copy the book and write their name. Anyone can copy the research paper and write their name. So we can prevent these all things. The decentralized governance is that I have already talked. That decentralized autonomous organization has the capacity. It is totally community based, and decisions are also taken on the basis of community voting rights. Obviously, there is a certain challenges, that is legal ambiguities is there, jurisdictional inconsistencies and enforceability of smart contracts. Technological limitations are also there because of the blockchain scalability, interoperability issues, adoptions of barriers are there, complexity of blockchain technology, as everyone is not knowing blockchain technology requires technical literacy to understand this all concept. Regulatory frameworks are obviously one challenge. The need for the updated laws to recognize decentralized ownership claims. Findings of the paper is decentralized intellectual property right enhances transparency, security, and fair compensation. It reduces reliances on intermediaries and empowers creators. Non-fungible token and decentralized autonomous organization enables innovative monetization models. Legal and technological changes remain significant barriers. Future successes depends on regulatory adoptions and technological advancement. Based on this, I have concluded that decentralized intellectual property right offers a transformative approach to digital rights management. Key advantages are transparency, automation, equitable revenue distribution. Challenges are there, that is legal recognition, scalability, interoperability. If I talk about the future research, then future research should focus on legal frameworks, technological improvements, and economic impacts. Thank you.
Thank you. Hello.
Hello, shall I present, sir?
Yes, ma'am. Yes.
Sir, I'm sharing my screen.
Okay.
Good evening, everyone. Myself Harshita Chaurasi, Assistant Professor, Department of Commerce and Management from Mata Gujri Mahila Mahavidyalaya, Autonomous Jabalpur. My research paper
Yes, sir.
topic is a study on the role of intellectual property rights in e-commerce. Sir, am I audible?
Yes, sir, ma'am.
Hello?
हाँ मैम
Hello? Am
जी
I
मैम
audible?
हेलो
Yes, ma'am. Yes, you are.
Okay. First of all, we have to know about what are intellectual property rights. Intellectual property rights refer to anything and everything that is a concept of the human mind that gives the individual an exclusive right over the creation of his intellect. According to Oxford Dictionary, intellectual property is an intangible asset resulting from human creativity. IPR includes copyright, trademark, patents, etc., and many more things. IPR includes the invention of product or process, a startup business, creating new music, and many more other things. Then we have to understand about the e-commerce. Electronic commerce in simple language is known as commercial transactions through online mode. It involves selling the goods or exchanging goods and services both by using internet. How IPR and e-commerce are interconnected. IPR in e-commerce is a highly valuable component of e-commerce. IPR stands for intellectual property rights, the rights that allow a business to use their invention to gain financial benefits and market leadership over its competitors. Despite its significant value, it is often neglected because most people fail to understand it and because its connection to e-commerce are not very obvious. Regardless, IP and e-commerce are entirely interdependent. E-commerce business is more than just products and services. It's built on intellectual property. IP is the lifeblood of our business value and success. Your brand name, logo, product designs, website content, and unique innovations contribute to your business identity and competitive advantage. Protecting these assets can be challenging. E-commerce law intersects with various legal domains and provides a robust strategy to safeguard your business long-term growth. The objectives of my study is to understand the role of intellectual property rights in e-commerce, and second objective is to study the importance of intellectual property rights in enhancing e-commerce. Third one is to study the about the legal strategies about IPR, which helps in protecting e-commerce. Types of intellectual property in e-commerce are trademarks, copyrights, patents, trade secrets, and many more. Role of intellectual property rights in e-commerce. Safeguarding, basically, intellectual property rights plays a very wide, important role in e-commerce. Like some of the roles are shared below. Safeguarding business interests of the company, safeguarding essential components, protecting products and patent license, safeguarding patent portfolios and trademarks, safeguarding the ownership of the factors that are involved in the business development. Importance of IPR in e-commerce. Following are the importance that makes an IPR an important part in e-commerce. Protection of innovation, brand protection, monetization, consumer trust, global competitive advantage, global protection, legal recourse. 8 elements that are protected under IPR in e-commerce: patent, software, website design, database of a company, websites, web page and graphic design, brand name, product name, website content, and many more. Conclusion: there is no denying fact that the fair and ethical compliance of digital practices and activities cannot be achieved without intellectual property laws, especially in a field as diverse and dynamic as e-commerce and retail. IPR in e-commerce helps business that operate on online platforms, since the online retail space is growing at an exponential rate. Intellectual property rights help companies safeguard and maintain their secret trade activities. IP rights in e-commerce also allow IPR owners to claim a share of the company's profit. As such, it should be said that IPR in e-commerce protect activities in the e-commerce field. However, the success rate depends entirely on the practical implementation of the IPR rights. Okay, sir. Thank you, sir.
Is there anyone who wants to present their papers?
So may I present?
Yes, sir. Yes, yes, sir. PPT दिख रही सर?
So may I present my paper?
हेलो
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 हेलो हाँ
Hello.
जी सर, PPT दिख रही सर?
no sir, please share your PPTs.
हेलो
हेलो
हेलो PPT दिख रही सर? PPT दिख रही?
No sir, no.
Yes. एक मिनट सर.
जाना होगा भगवान।
सर बेसिकली मैं एमपी से हूँ।
एमपी से?
हाँ जी।
यहाँ क्या कर रही है?
यहाँ मेरी शादी हो गई एक्चुअली।
आप गुजराती हो?
हाँ तो
नजदीक आ गए।
Unmute, please unmute this sound.
देखिए मैं बताती हूँ, हाँ शांति से बताती हूँ। मैं भगवान में बहुत मानती हूँ।
हमको नहीं मानते।
नहीं, आप मुझे अच्छे लगते हो। एंड मतलब अब भगवान को मानती हूँ, हनुमान चालीसा करती हूँ, शिव जी की बहुत बड़ी भक्त हूँ। आपसे मिलने की इच्छा थी।
रेवा मैम हेलो
कैसे कैसे
हेलो
बट मैं वहाँ बैठ के झूठ नहीं बोलती, मेरा दिल बहुत साफ है। मैं वहाँ बैठ के यही बोल रही थी कि ये सब सेटिंग है क्या यार, बट आपने मुझे बुला लिया। मतलब आई एम रियली मतलब स्पीचलेस।
ऐसे भी लोग गुजरात में पाए जाते हैं।
सॉरी, आप बोल रहे थे।
Is there anyone who wants to present their PPT?
Yes sir.
Please sir, please.
स्क्रीन शेयर नहीं हो रहा सर.
Next. आप बाद में कीजिए सर.
Okay.
और एक है कोई तो भी.
So may I present?
Yes, please ma'am, please.
But sir, but PPT is not there. I sit and speak. My name is Lieutenant Bharti Tiwari, and the title of my paper is on the role of intellectual property rights in empowering women entrepreneurs. The overall gist of my paper is that intellectual property right plays a crucial role in empowering women entrepreneurs by providing them with exclusive rights to their creation, invention, and innovation. These rights include patent, trademark, copyrights, and industrial design, incentivize creativity, foster innovation, and enable women entrepreneurs
to build sustainable and competitive businesses. By protecting their intellectual property, women can leverage their unique ideas and creation to generate revenue, attract investment, and build strong brands. Intellectual property rights also empower women by providing legal tools to protect their creations from unauthorized use and exploitation, ensuring they receive fair compensation for their intellectual contribution. Furthermore, access to an understanding of IPR can help women entrepreneurs navigate the competitive business landscape, build strong business models, and contribute significantly to economic growth and social development. We can see that in recent years, women entrepreneurs have drawn a lot of attention as a possible force behind gender equality and economic growth. We can say that although the proportion of female entrepreneurs has been increasing, women frequently encounter particular difficulties such as lack of support network, cultural prejudices, and restricted access to resources. By giving them the required legal protection for their invention, concept, and creative work, intellectual property right can be extremely important in empowering female entrepreneurs. My study explores the relationship between the women entrepreneurs and intellectual property right by emphasizing the ways in which robust IP frameworks can support female entrepreneurs, their financial independence, inventiveness, and also through these papers we have seen like how the women entrepreneurs are facing a lot of challenges and obstacles. There are many informal women entrepreneurs who are still have not their IPR, or you can say the right for their business. And in conclusion, I can say by offering legal frameworks that safeguards their inventions and breakthrough, intellectual property rights have a great deal of potential to empower female entrepreneurs. By using the effective use of intellectual property rights, can be promote innovation, increase women economic independence, and increase their participation across a range of industries. Through this, women entrepreneurs can obtain a competitive advantage, draw in investments, and create long-lasting companies by protecting their intellectual property. Thank you. Thank you so much.
Thank you, ma'am. Thank you. Pavra, sir. Pavra, sir.
Okay, sir.
Yes. I think you are last, sir.
सर पीपीटी प्रेजेंट नहीं हो पा रही।
हाँ दिख रही है सर।
दिख रही सर?
यस
ओके सर, थैंक यू सर। मेरा नाम है जगदीश पावरा सर, शासकीय स्नातकोत्तर आदर्श महाविद्यालय झाबुआ मध्य प्रदेश से हूँ, और मेरा टॉपिक है बौद्धिक संपदा का समाजशास्त्र। और इसमें मैं इंट्रोडक्शन बताऊंगा। बौद्धिक संपदा का वह अधिकार है जो किसी व्यक्ति को अपने रचनाओं, आविष्कारों और विचारों पर मिलते हैं। किसी उत्पाद, विचार या रचनात्मक कार्य को कानूनी सुरक्षा प्रदान करते हैं ताकि निर्माता या आविष्कारक उसे अन्य लोगों से पहले उपयोग कर सके। इसके होने वाले लाभ
So you are not audible. आपका आवाज नहीं आ रहा है।
बौद्धिक संपदा का समाजशास्त्र उन सामाजिक, सांस्कृतिक और आर्थिक पहलुओं का अध्ययन करता है जो बौद्धिक संपदा के अधिकारों से संबंधित होते हैं। यह क्षेत्र ये समझते समाज और व्यक्तियों के बीच शक्ति, न्याय और हेलो
जगदीश पावरा जी। हाँ प्लीज सर।
जी सर, आवाज आ रहे हैं?
यस सर।
ओके। इस रिसर्च पेपर में हम बौद्धिक संपदा के विभिन्न पहलुओं का समाजशास्त्र के दृष्टिकोण से विश्लेषण करेंगे। इसमें हम बौद्धिक संपदा प्रभाव और इससे संबंधित विवादों पर चर्चा। बौद्धिक संपदा का इतिहास और विकास। बौद्धिक संपदा का विचार प्राचीन काल से ही अस्तित्व में था, लेकिन इसका औपचारिक रूप से अस्तित्व आधुनिक समय में ही हुआ। 17वीं और 18वीं शताब्दी में यूरोप में औद्योगिक क्रांति के दौरान बौद्धिक संपदा के अधिकारों का अवधारणा विकसित हुई। इसका मुख्य उद्देश्य यह था कि रचना, रचनाकारों और आविष्कारों को उनके कामों पर कानूनों सुरक्षा मिल सके ताकि वे अपने विचारों से आर्थिक लाभ कमा सके। और 1787 में संयुक्त राज्य अमेरिका में संविधान के अंतर्गत पहला पेटेंट कानून लागू हुआ जो बौद्धिक संपदा के अधिकारों को कानूनी रूप से सुरक्षा प्रदान करता था। धीरे धीरे बौद्धिक संपदा के अधिकार का प्रसार हुआ, दुनिया में हुआ और 1995 में विश्व व्यापार संगठन WTO द्वारा ट्रिप्स समझौते के तहत बौद्धिक संपदा के अधिकारों को वैश्विक स्तर पर मान्यता प्राप्त हुई। बौद्धिक संपदा का समाजशास्त्र बौद्धिक संपदा का समाजशास्त्र यह समझने की कोशिश करता है कि यह अधिकार कैसे समाज के विभिन्न वर्गों जैसे रचनाकारों, उपभोक्ताओं, कंपनी और सरकारों के बीच शक्ति और संसाधनों का वितरण करते हैं। बौद्धिक संपदा के अधिकारों की संरचना यह निर्धारित करती है कि कौन सा वर्ग किस हद तक लाभान्वित होता है और कौन सा वर्ग हानि का शिकार होता है। बौद्धिक संपदा और शक्ति का वितरण। बौद्धिक संपदा के अधिकारों के संरचना समाज में शक्ति और संसाधनों का असमान वितरण को स्पष्ट करते हैं। उदाहरण के तौर पे स्वरूप बड़ी कंपनियां और बहुराष्ट्रीय निगम अक्सर बौद्धिक संपदा के अधिकारों का अधिकतम उपयोग करते हैं, जबकि छोटे निर्माता और देश उसके लाभों से वंचित रहते हैं। इससे एक आर्थिक असमानता उत्पन्न होती है क्योंकि बड़े निगमों के पास अधिक संसाधन और अधिकार होते हैं, जबकि छोटे निर्माता अक्सर अपने विचार और रचनाओं को कानूनी सुरक्षा नहीं दे पाते हैं। कानूनी और सांस्कृतिक प्रभाव बौद्धिक संपदा का समाजशास्त्र यह दर्शाता है कि अधिकारों का निर्माण और उसके प्रभाव में सांस्कृतिक और कानूनी दृष्टिकोण का महत्वपूर्ण योगदान है। विभिन्न संस्कृतियों और देश में बौद्धिक संपदा के अधिकारों के प्रति दृष्टिकोण भिन्न हो सकते हैं। उदाहरण के लिए विकसित देशों में बौद्धिक संपदा के अधिकारों की रक्षा के लिए बड़े कानूनी उपाय होते हैं, जबकि विकासशील देशों में ऐसे अधिकारों का संरक्षण कमजोर होता है। इसके परिणाम स्वरूप वैश्विक असमानताएं उत्पन्न होती हैं। इसका प्रभाव आर्थिक विकास और नवाचार पर पड़ता है। समाज में बौद्धिक संपदा के अधिकारों का नैतिक पहलू। बौद्धिक संपदा के अधिकारों का समाजशास्त्र यह भी दर्शाता है कि अधिकार सामाजिक दृष्टिकोण से नैतिक सवालों को जन्म देते हैं। क्या किसी बिना विचार रचना पर अधिकार अपने विचारों या रचनाओं से दूसरों को लाभ उठाने का अधिकार है? इस प्रकार के सवाल समाज में बौद्धिक संपदा के अधिकार के प्रति समाज के दृष्टिकोण को प्रभावित करता है। हेलो
हेलो, हो गया सर?
जी सर, नेटवर्क इश्यू आ गया सर।
ओके सर, ओके सर। इज देयर एनीवन
जी सर,
प्रेजेंट?
ओके, थैंक यू सर।
ओके, ओके।
Hello, yes, sir, this is Dr. Bhavya Nagin from
Thank you.
Government and Arts Commerce Majholi CD. So can I start?
Pavra sir, please stop your screen sharing, sir. Pavra sir, please stop your
Okay,
screen,
okay. Just a minute.
screen
Yes,
sharing.
yes,
Wait,
yes.
madam. Okay, ma'am, continue.
Okay. Sir, I don't have PPT, but I just want to share my views on my
Okay.
topic.
Oh,
Yes.
yes.
Very good afternoon to all of you. I am Dr. Bhavna Nagin from Government Arts and Commerce College, Majholi, Seedhi. My research topic is the role of intellectual property rights in Indian context. Yes, I want to review what is I just want to start what is related to human brain applied for creativity and innovation. In that way, we can see it is the output of manpower, time, energy,
Ma'am, you are
skills,
also not
and
audible,
money.
ma'am.
Hello? Hello? Am I audible, sir? Hello? Am I audible, sir? Hello.
Hello,
Hi.
Bhavna madam.
Now, am I audible, sir? Hello.
Am I audible?
Please, can you hear me? Hello. Yes, sir. Am I audible? Hello. Hello. Am I audible, sir?
Yes, yes, yes. Please, please.
Yes, sir. So I want to discuss my research topic, the term of intellectual property rights. It is related to human brain applied for creativity and innovation. So the output of this is the output of manpower, time, energy, skills, and money, etc. So if we want to put these all things, we can get various or we have classifications of IPR. It is follows. First is patents, then trademark, industrial designs, layout designs of semiconductors, and geographic indicators of sources, copyright and related rights. That may include artistic work, musical work, artistic work and photography, and computer programming, performing arts, and broadcasting also. So if we see the IPR in India or in Indian context, we can say nowadays we have opportunities to utilize IPR at different levels. The IPR is basic necessity to be the part of local as well as global competitive trade, as without dissemination of IPR knowledge and implementation, creating the innovation and environment is really impossible at some time. It is essential for policymakers in India to include IPR in basic educational system and to promote IPR administration by encouraging the innovations and creations. India is having all the resources in terms of like we have available materials, cheap labor, innovation and creative dedicated manpower. We have these all things, so definitely we can create good marks in international level or at international level. No doubt, India and the other developing countries will definitely harness its promotion and share in global by exploration. So here, sir, I want to complete my. Hello, yes, sir, am I audible?
Yes, ma'am. Yes, yes. Please
Hello.
conclude, ma'am. Please conclude.
Okay. So that's it, sir.
Okay, okay. Thank you, ma'am. Thank you.
Thank you so
Is
much.
there
Thank you.
anyone? Okay, okay. Is there anyone other who wants to present their papers?
Thank you, sir.
Is there anyone? Okay, now it's time of vote of thanks. I'm here for vote of thanks. On behalf of our institution, MSP Mandas Yeshwantrao Chauhan College, Ambazogai, I extend my sincere gratitude to our esteemed chief guest of today's program, Dattaba Patil, and Azruddin sir and Mehzabin madam for sharing their valuable insights of intellectual property rights. A special thanks to our distinguished speakers and presenters and panelists of their enlightening discussions in offline and online mode also. I also appreciate the host of this online session, Dr. Rafi sir, for the hosting this session. And also, I'm very much thankful to our principal of our college, Dr. Shivdas Shirsat sir, for their support, as well as their organizing committee and volunteers for their dedication. Lastly, I am very much thankful to the convener and coordinator of this today's seminar, Dr. Indrajit Bhagat sir, Pallewad sir, and Bhosle sir, Sunil Bhosle sir. And lastly, a big thank you to all the participants for their enthusiastic engagement. Thank you. Thank you, everyone. Thank you.
Thank you, sir. Thank you, sir.